Thank you, everyone. It's a real pleasure to see everyone, and I recognize some faces in the room from past programs here at the Historical Society, and some that we've co-sponsored by the Encyclopedia of Greater Philadelphia, with which I edit, so welcome again. As Beth said, this is part of a continuing series, so you have opportunities to continue this conversation after this evening. And I do think it's very notable that we're presenting this on the 150th anniversary of the 13th Amendment to the Constitution, which ended slavery, by showcasing 4 documentaries in the series, one tonight, all produced with the help of the National Council for the Humanities. So we've had one great program at the African American History Museum in Philadelphia. We'll be continuing on March 26th at the National Constitution Center, and then wrapping up at the Philadelphia History Museum. And as Beth noted, the title of the series does include a question mark, and the reason we put a question mark on Created Equal is to signal that this is a film and discussion series, that the series is not only about providing access to information and providing answers, but also raising questions, inviting your conversation, and exploring the resonance that history has for our own times. The goal overall of the series is to encourage discussion about history and contemporary issues. Connecting the past and the present in that way will certainly be in tonight's discussion as we watch a portion of the documentary, The Loving Story. Are some of you familiar already with the film? And many are seeing it for the first time. So we're going to be seeing a film here that's the story of a Virginia couple who were arrested under a state law prohibiting interracial marriage, and their case challenging that law. So we'll have an opportunity to explore the historical context of the case, as well as to discuss its implications for the continuing contemporary definitions of marriage. Here to set the stage for the film this evening, we have 2 additional guests. Mark Aronczyk, who is not so much a guest, but a board member of the Historical Society as well, is a litigator and chair of the Hangley, Aronczyk, Siegel, Pudlin, and Schiller, chair of litigation, right? Is that right? Chair overall of the firm. And he will share how the Loving case set precedent for the recent state and federal court battles over gay marriage. He was involved in the federal lawsuit on behalf of 21 gay Pennsylvanians who wished to marry in the Commonwealth. We're also joined by Regina Austin, the William H. Nader Professor of Law and Director of the Penn Program on Documentaries in the Law, and she will be providing historical context based on her academic interest in race, gender, and class oppression. So we'll first invite to the podium to set some context for the film, Professor Austin.
Thank you. I'm very happy to see a large audience of folks who are interested in this documentary to begin with. I teach documentaries in the law, and I think this is a very, very lovely documentary. It's about an interracial marriage that seems to me to be a very good marriage by any standard. The archival footage, the verite fly-on-the-wall footage was by cinematographer Abbott Mills. The still photography was taken by Gray Villett for Life magazine. The footage, the stills, are used to produce a visually stimulating and engaging portrait of 2 ordinary people, one black and or Native American and female, the other white and male, both poor and purportedly lower class. Neither had a high school degree, but they took extraordinary steps to live together as a family in the Virginia hills that they called home. It appears from the film that Mildred Loving was a bright, serene, charming, attractive young woman. Her husband Richard was a man of few words, fewer smiles, and I suspect his poor teeth had something to do with that, and limited means. He was a bricklayer who looked like a stereotypical redneck, according to one of his lawyers. He worked with his hands in his back, yet he was also a gentleman, as his caresses of his wife and his interactions with his children reveal. The genuine affection that you see displayed on the film suggests that theirs was not the sort of interracial pairing that was one careless epithet away from the whole thing falling apart. There is genuine love exhibited in this film. They married in 1958 when Mildred was 18 and pregnant. And their troubles with the law and their exile from their homes started with a tip to the police indicating that they were violating Virginia's racial integrity law. The raid came at night when they were in bed, but alas, they were not making love at the time. That would have increased the penalties. It's hard to understand how the Lovings made the kind of enemies who would have taken pleasure at driving them from the community. They left and wound up in Washington, D.C. at about the same time I was growing up in Washington, D.C. But ultimately their situation proved intolerable, and they came to understand that it was an injustice according to their own terms. Richard tells his lawyer to tell the justices of the Supreme Court, "I love my wife, and it's just unfair that I cannot live with her in Virginia." But those are not the terms on which the Supreme Court would consider the case and render a decision. The Lovings did not see themselves as civil rights pioneers. What they wanted for themselves, and it was pretty modest as they thought about it. Obtaining it, of course, was not easy. The Lovings had to resort to a lawsuit, and they had to have lawyers to bring it for them. But their lawyers came from the NAACP, their lawyers came from the ACLU and not the NAACP Legal Defense Fund. LDF stayed out of challenges to anti-miscegenation laws because they were based on primitive notions of black biological inferiority and the social stigmatization of mongrels. As a threat to the integrity of the white race, intermarriage was too hot a potato for the LDF to take on the cases. And black advocacy groups of their kind feared that attacking such laws might undermine campaigns directed at educational and employment discrimination. Moreover, marrying white people was not high on the list of blacks' quest for freedom and equality. So that's the context in which the case was litigated and in which it arose. You should know that 6 months after the Supreme Court rendered its decision, Guess Who's Coming to Dinner premiered. So that the society had changed by the time the court got around to striking down the law. After you see the Loving story, we will talk about the significance of Loving versus Virginia and the Loving story as an iconic tale of racial justice and the struggle for marriage equality.
Almighty God created the races, white, black, yellow, Malay, and red, and He placed them on separate continents. And but for the interference with His arrangement, there would be no cause for such marriages. The fact that He separated the races shows that He did not intend for the races to mate.
skinny and it's easily called a string bean. And then eventually he knocked off the string and called me.
Where's your boots, man? You won't get your own. Yeah. We were married on the 7th day of June, and the police came after us the 14th of July. It was about 2 a.m. And I saw this light, and I woke up and there was the policeman standing beside the bed, and he told us to get up, and he was under arrest.
They came one night and they knocked a couple times at her, and before I could get up, they just broke the door and came on in. When we got up, they just stand beside the bed with flashlights.
They asked Richard who was that woman he was sleeping with. I said, I'm his wife, and the sheriff said, not here, you're not. And he said, come on, let's go.
They knew he was coming, Sheriff Brooks. They had gotten the word, and he had been there several times in the daytime, and didn't have a home. So when at 4 o'clock in the morning, they were there.
The lady cars the door and locked us up.
Our jail was hell. It had 16 bunks in it, but it wasn't no motel. When she was arrested, she was put in the small cell, the woman's cell. They had a sink and a commode, and you get a little something to eat through the door. We could only take one woman.
One afternoon, this inmate had been out on the outside working, and when the sheriff brought him back in, he said, I should let you go in here with her tonight. Oh, it scared me to death.
I mean, the way I feel about it, it's just a few people that live in this community. It's a few white, it's a few colored. And we all, as we grew up, and as they grew up, we all helped one another. It was all, as I say, mixed together, started, so it just kept going that way. It's been that way for years down here. It's a lot of it down here, but we're the only ones that involved with it. It's a lot of the same down here.
Is that right?
Yeah, but see, it just, some people that didn't like it, they just talk, say, and started to talk over.
Do you know any other couples who were in the same situation?
Yeah, I know some, but I don't like calling names.
No. I just wondered if you did.
Yeah, I know. You.
Wonder why they picked on you then?
That I don't know. I'll never find out. Somebody talked.
The Lovings were married in 1958 outside of Virginia, here in the District of Columbia. But they were convicted under Virginia law, which forbids any white person and colored person from leaving the state for the purpose of marrying each other and with the intention of returning. They were sentenced to a year in jail, but the sentences were suspended on condition they leave Virginia. The legal term is miscegenation, and those who support such laws claim they are necessary in order to preserve the purity of the races. In all the field of race relations, probably nothing is more sensitive than the issue of intermarriage.
Daisy was very miserable. She felt, totally divorced from the world. Aside from the fact that she had been banished there and was living there because some judge had said that you can't live with your husband in Virginia, she never really adapted to city life. Growing up in the country in a rural area where she had room and her children had room to play, being in the city just was not what she was accustomed to.
We came home on Christmas and I was born. We were here in Virginia. They could come back separate. They couldn't come back together. But knowing them, they probably came back together. My daddy was very firm. He didn't say much, but when he put his mind to something, he's going to do it. And when they wanted to come back to Virginia for any reason, they're going to come back together. They just take their chance. Once they got back, they might have been shaky about being rearrested. Friends will let them know, if they hear anything. Little conversations, and it's kind of like a whisper. We're not supposed to be here. We're hiding.
My great uncle's house, we called it the big house, but it was actually a boarding house. That certainly made it easier to slip in and out unnoticed. I would always know when Mildred was in town because the children, usually the oldest boy, Sidney, would come over and we would play. And I often played with Sidney, just the two of us. And sometimes the other younger siblings would play with us as well. And then I knew that Mildred was there in the house visiting her sister, Garnet. And then later on in the evenings, we would see Richard coming in, usually from the other direction. You never saw him outside. He was always inside the house.
The children didn't have anywhere to play. They were like being caged, and I couldn't stand. I couldn't take it. My oldest son came back and told me that Donald had been hit by a car. I didn't know what to do. I knew I had to go to him, but I didn't know if he was dead or... He was sitting up in the street corner, and I think that was the straw that broke the camel's back. I had to get out of there. I was so unhappy. I was complaining to my cousin constantly. So one Saturday, I guess she got tired of it. She told me, she said, write to Bobby Kennedy. He'll have it. That's what he was up there for.
Just 100 years after Lincoln signed the Emancipation Proclamation and freed the slaves, 200,000 of people converge on the nation's capital to rally for civil rights. They come by train, they come by bus and by air. They come from the north, the south, the east and west. They come united in one cause, to urge Congress to pass a civil rights bill to end forever the blight of racial inequity. This great throng with a cause gathers on the
I wasn't involved with the civil rights movement. The only thing I know is what everybody saw in the news. I knew Dr. King was everything. I never met him. I would have loved to, but I didn't. I wasn't in anything concerning civil rights. We were trying to get back to Virginia. That was our goal, to get back home.
How did you find out what to do?
She wrote to, we write to,
To Ron, did he answer?
And he told me to, he said there was one thing he could do, but to write to the American Civil Liberties Union. And I wrote to them, and I told them what happened, Mr. Kennedy asked me to write to him. And I guess it was for me, and Mr. Gorman told me that he was going to take the case.
Well, when Mr. and Mrs. Loving were having their problems, they wrote to the Attorney General of the United States, who was then Robert Kennedy, and asked if the civil rights bills that were being discussed in Congress at that time, let's say I guess it was 1963, would give them any relief from their problem. And he wrote back and told them that it would not, but suggested that they get in touch with the American Civil Liberties Union. Here's the date, so we can be sure, and that was June 20th, 1963, and we're living in Washington, D.C. at the time. Dear sir, I'm writing to you concerning a problem we have. 5 years ago, my husband and I were married here in the district. We then returned to Virginia to live. My husband is white. I am part Negro and part Indian. At the time, we did not know there was a law in Virginia against mixed marriages. Therefore, we were jailed and tried in a little town of Bowling Green. We were to leave the state to make our home. We have 3 children and cannot afford an attorney. We wrote to the Attorney General. He suggested that we get in touch with you for advice. Please help us if you can. Hope to hear from you real soon. Yours truly, Mr. and Mrs. Richard Loving. And it was that simple letter that got us into this not-so-simple case. Relics of slavery, and they're maintained to keep the colored person down and the white person up, and that's the simple truth of the case. And I think that if you talk to the average man on the street, he would tell you that marriage is a fundamental right of man.
This is my personal opinion. I think that the problem goes back into your basic beliefs. And I think that the basic thing that the people of the South are thinking about is a mixture of the races. And I don't see how you can keep in a mixture of the races if you have immigration. I'm not saying that it will happen immediately, but I say that some of the lower class white people will probably marry with some of your better liberals perhaps, or some of your lower liberals, that God will in time come forth one of those who will marry with some of your better class white people, you farmers around here, you're people who own their own farms, and the first thing you know, we would be along the ways.
Segregation from the very beginning was fundamentally about sex. It was designed to prevent men and women of different races, black and white, from occupying the same spaces in which they might be tempted. And so the more intimate a space was, a railroad car, a parlor, a restaurant, a schoolroom, the more likely it was to be segregated. Ironically, the Loving case, being about love, being about sex, is actually what segregation was about all along.
Challenging the anti-miscegenation laws was
the most serious threat to the white racists, and even those whites who were not racist but were very pro-establishment. I looked at it as a unbelievable challenge for a lawyer 1 or 2 years out of law school to be getting involved in what was sure to be a major civil rights case.
Number 395, Richard Perry Loving, et al., appellants, versus Virginia. Mr. Hirschkopf.
Mr. Chief Justice, may it please the court, I am Bernard A. Cohen. I would like to move the admission of Mr. Philip J. Hirschkopf, Pro Hoc Vice, my co-counsel in this matter. He is a member of the Bar of Virginia.
Your motion is granted. Mr. Hirschkopf, you may proceed.
Thank you. You have before you today what we consider the most odious of the segregation laws and the slavery laws. And our view of this law, we hope to clearly show, is that this is slavery law. These laws rob the Negro race of their dignity. It's the worst part of these laws. And that's what they're meant to do, to hold the Negro class in a lower position, lower social position, a lower economic position. We ask that the court consider the full spectrum of these laws, and not just the criminality. Because it's more than a criminality that's at point here, but the legitimacy of children, the right to inherit land, and many, many rights. And in reaching a decision, we ask you to reach it on that basis.
Mr. Cohen.
Mr. Chief Justice, may it please the court. What is the danger to the state of Virginia of interracial marriage? What is the state of the danger to the people of interracial marriage? Marriage is a fundamental right or liberty. And when we go further and urge that the courts say that this is a fundamental right or liberty retained by the people within the meaning of the Ninth Amendment and within the meaning of liberty in the Due Process Clause of the 14th Amendment, well, surely that's I suppose you would agree that the state could forbid a marriage between a brother and a sister, would you?
And Mr. McElwain.
It is a matter of record, agreed to by all counsel during the course of this litigation and in the brief, that one of the appellants here is a white person within the definition of Virginia law, the other appellant is a colored person within the definition of Virginia law. Thus, the court is simply faced with the proposition, well or not, a state may validly forbid the interracial marriage of two groups, the white and the colored, in the context of the present statute. The state has a natural, direct, and vital interest in maximizing the number of successful marriages which lead to stable homes and families, and minimizing those which do not. It is clear from the most recent available evidence on the psychosociological aspect of this question that intermarried families are subjected to much greater pressures and problems. It is not infrequent that the children of intermarried parents are referred to not merely as the children of intermarried parents, but as the victims of intermarried parents and as the martyrs of intermarried parents. And that the state's prohibition of interracial marriage for this reason stands on the same footing as the prohibition of polygamous marriage or incestuous marriage or the proscription of minimum ages at which people may marry and the prevention of the marriage of people who are mentally incompetent.
There are people who have the same feeling about interreligious marriages, but because that may be true, would you think that the state could prohibit people from having interreligious marriages?
I think that the evidence in support of the prohibition of interracial marriages is stronger than that for the prohibition of interreligious marriages. But I think that the...
How can you say that?
Well, we said that
because you believe that. Didn't we in the segregation cases have also argued to us what was supposed to be scientific evidence to the effect that the whites would be injured by having to go to school with the Negroes?
Your Honor,
Isn't that the same argument you're making here?
yes, sir, it is.
I think what the Attorney General did was immoral. In the way this case was prosecuted, I think that the argument they made was immoral, that children from mixed marriages suffer because they knew the whole purpose of the statute was to preserve racial integrity. And Mr. McElwain had an alternative to say, I can't argue this case. I believe it is improper, immoral, not accurate. He presented a false argument to the United States Supreme Court of this is really to preserve the rights of some young children, knowing that is not what the statute was about.
That is the right of Richard and Milton Loving to wake up in the morning or to go to sleep at night, knowing that the sheriff will not be knocking on their door or shining a light in their face in the privacy of their bedroom for illicit cohabitation. The Lovings have the right to go to sleep at night, knowing that should they not awake in the morning, their children would have the right to inherit from them under intestacy. They have the right to be secure in knowing that if they go to sleep and do not wake in the morning, that one of them, a survivor of them, has the right to Social Security benefits. All of these are denied to them. No one can articulate it better than Richard Loving when he said to me, Mr. Cohen, tell the court I love my wife, and it is just unfair that I can't live with her in Virginia.
It's a slow train, but it's moving on. I've got my ticket. Don't pass me by. If I don't get on, oh, I'll bring right down and cry. Only got one life to live on this earth. Oh, get me there, won't you please? Conduct a search. It's a slow train, but it's moving on. Everybody gets a ticket, you and me. It's up to you to catch a ride. That's how it's gotta be. Everyone there has to prove he's a man. Take it easy on yourself. Oh, there's no helping it. It's a slow train, but it's moving on. It's a slow train, but it's
So we're going to give Mark a chance to talk a little bit about this case as a precedent for his work.
Okay, Alabama, can you believe it? I mean, really, you know, it's just, I mean, God is great. It's just unbelievable. We're going through the same thing again with Alabama. I was the lead lawyer in the Whitewood case, which last May resulted in the ruling that the Pennsylvania ban on same-sex marriage was unconstitutional. And the next day, the governor, Corbin, of all people, chose not to appeal. And I can tell that, I can spend a long time telling you how we got both results, both the win, and we had a lot to do with the decision, his decision not to appeal. Worked with the ACLU. We were brought in by the ACLU. I'm the chair of a firm in town that will happily take on big causes, and this was something that didn't take us more than a nanosecond to agree to do. It cost us a lot of money, spent a lot of time, probably among the best things I've ever done. And in the questions, if anybody has any questions specific to the case, the strategy and all of that, I know that's no longer here, but I'll try to address them. I think I want to say a couple of things. One, generally, the way these cases are won is that the right people come forward to be your plaintiffs. It's not the lawyers. The lawyers have something to do with it. I appreciate Mr. Cohn's remarks about how hard his project was, and ours was too, but we're trained to do that, and that's what we do. But when the individuals come forward and want to put their necks on the line and put themselves out in litigation, it's not easy. That's what can really turn the tide. And in this case, the Lovings, aside from their name, you couldn't have a more perfect couple to challenge the anti-miscegenation laws. And in our case, we had over 20 plaintiffs who were very much like that, from a total cross-section of Pennsylvania, and every characteristic you could possibly want, bringing the charge. So hats off to the plaintiffs. The other parallel that is really, remarkable is that we are practically at the same spot that the folks in Loving were. We have about the same number of states now that recognize same-sex marriage. They had 34, we have 35. The Supreme Court had laid a little bit of the groundwork before Loving, and then closed the door in their case in Loving. Same in our case, the Whitewood case about a year and a half ago. Sort of, I think, presages, is that the right word, which way the Supreme Court is going to go, I predict, in the case going to be argued on April 28 and probably a decision in June. Why is Loving important to what we're doing? Let me say a few words about that and a little bit about the controversy in Loving as a precedent for what we're doing. It's important because Loving as a legal matter was centered on what's called the Due Process Clause of the 14th Amendment and found a fundamental right to marry. It said, it conditioned it, or at least had the words in there, a fundamental right of people from different races to marry. But really, the logic of the opinion and the way it was developed premised on a fundamental right in our Constitution for marriage. And there are two principal arguments in front of the Supreme Court in June. One is there a fundamental right to marriage, or does the fundamental right to marriage extend to same-sex couples? Do they also have a fundamental right to marry? And then the other is an equal protection argument, which is a little different, and we'll put that on the side for a second. Because Loving is the principal precedent for the fundamental right to marry. And we believe that everything about that precedent supports the rights of same-sex couples to marry. The arguments that were advanced in Loving, and more importantly, the arguments that were advanced in all the cases that led to Loving, many cases around the country, many state Supreme Courts The arguments by the opposition are the same types of arguments that are being advanced in opposition to same-sex marriage and whether there's a fundamental right. The religious argument, the kind of God's plan argument that many state courts rested their decision on, is the same kind of argument that's being advanced here about God's plan. God's plan was for no interracial marriage, God's plan is for no same-sex marriage. It's all God's plan. The children as victims, same kind of argument. Back then, children are going to be ridiculed, they're not going to get ahead, they're going to be held behind, they're going to be hurt in school, they're going to be second-class citizens, and all that stuff we had to deal with and wade through. In our case, same arguments, scientific, fake science. These scientists, we so overwhelmed the quote scientists on the other side that they chose not even to file their reports in our case. They gave up. In our case, they did not even advance the junk science. That's how much we beat them down. But we took all of the things that they'd been saying over the years and we destroyed it all. But it's the same idea. It's going to hurt children. The slippery slope. It's going to lead to polygamy. And I had a letter I loved from, they never signed. They always send me letters, but they never signed. But one that I loved was how he predicted my next fight would be to allow lawyers to marry dogs. And he hoped that I would actually advance that argument because that's what we deserve to marry. But the slippery slope arguments, the arguments about tradition, the same kind of thing. The tradition in the United States before loving, since the founding of the country, was races married within the same races. The tradition in the United States ever since the founding of the country is there are no same-sex marriages. The same fundamental type arguments. So the fact that they were mowed down in loving is a setup for mowing the same ones down in our case as well. So that to win, ultimately in loving, the victory was, I think, based on a moral argument, which is evident from the nature of the plaintiffs they had. We have people who love each other, who raise a family, want to be together, and the morality runs 1,000% in their direction. Why shouldn't they be? And who are we to say that's good for us but not good for you? How can you? It's that fundamental. How can you be a discriminator when you see the lovings? It's the same moral argument for us. When you have people who love each other, raise families, pool their resources, commit to the society and be good citizens, the moral argument runs 1,000% in the same direction. Who are you to be a discriminator? Who are you to say they don't have the right you have? And how in the world, in looking at this, or looking at what we advance, could you say that heterosexual marriage, or the concept of marriage, is weakened? It's preposterous on its face. It only strengthens our idea of love and marriage. And so it's the similar kind of, it's exactly actually the same kind of moral argument. The last thing, and I predict that the types of arguments that were made in opposition, when you listen to the tape of the argument, you can listen to it live on C-SPAN, in the same-sex marriage case on April 28th, you'll hear the same kind of things dressed up in more modern language, exact same thing. And I think you'll hear the same kind of questioning, at least from, Kagan and Breyer and Ginsburg and Sotomayor and hopefully Kennedy, and maybe even Roberts. I suppose, it would be amazing to think it would go past that, but maybe it even could. But you'll hear the same kinds of things. Two last points I want to make. One is that the Attorney General today, Eric Holder, deserves, I think, a lot more credit as a principled person and a hero than McElwain deserved back then. In that you really, at some point as a lawyer, I was the city solicitor for Philadelphia, so I say this with full knowledge of what the obligations of a lawyer for the public are. I was the chief lawyer for the city. But at some point, you have limits. You can't make, immoral or nonsensical arguments. And at least Holder recognized that in the Windsor case. Kathleen Kane did in our case, and she chose not to defend the statute, a great attack against her. She was one of the 3 attorney generals at the time that took that position, all women. Coakley, Madigan in Coakley in Massachusetts, Madigan in Illinois, Kathleen Kane. And then that opened the door to lots of other attorney generals taking the same position. But it is an interesting piece of history to see when public officials will actually have the courage to do what they should do. The controversy around the use of loving is one that, as a precedent for our case, is one that I know we'll address. I don't fully understand. The right wing will say loving is only a vestige of slavery. It has nothing to do with a fundamental right beyond black and white. I guess they say it has nothing to do with any other race, just black and white. And it's unique, and it's cleaning up slavery. And sure, it was doing that. There's no question by any measure that, of course, it was doing that. It was a major, major issue. But there are elements in the civil rights community in the United States, meaning people who would otherwise support same-sex marriage, who are not in favor. There's a small group, but there are elements who are not in favor of using loving to support same-sex marriage, because somehow or other it's taking loving out of its historic context, or what it really, really means in terms of the racial justice in the United States. That I don't understand, because if anything about racial justice means anything, and I've fought those fights, or religious equality or anything, it's to set a principle that then applies to everybody. It's to advance, to make us a more perfect union, to advance a principle out of somebody else's felt impossibly difficult and improper experience, and generalize that principle to the other people who are suffering from the same thing. But there is still this controversy that surrounds, controversy is too strong a word, there is a argument that is made about whether or not loving is properly used or not. I think it is, unequivocally. I used it, it was used, we won our case in part, we won our case on both principles. And I hope the Supreme Court says that as well, because if they do, they will be setting a standard of marriage, fundamental right to marriage, that that means everything we want that fundamental right to mean. That it's not just available for some people, it's available for all people with similar, who love each other, basically, and want to be with each other. So those are my beginning comments, and wherever you go with the questions, I'm happy to go there.
Regina, could you help us understand the concern about loving as a precedent case?
Sure. If you came for a kumbaya, we're all in this together. You don't know me. Yeah, there are problems with using loving as a precedent, and there are also there's loving the iconic story, the loving that's used in the sort of parallel struggle, which is a political one and a social one and an economic one and a cultural one. So the law has a way of decontextualizing disputes and translating them into its own sort of arcane language and principles that may or may not relate to how people outside of the law see and talk about a problem. So in this case, Richard said, I want you to tell the court that I love my wife and that it's unfair that I can't live with my wife in Virginia. The lawyers had to translate that into legalese, which meant that they had to talk about marriage as a fundamental right and the Equal Protection Clause as being a bulwark against criminalizing race, which is basically what this was. So you have two ways of looking at the same problem, and to a certain extent, that kind of duality is continuing with regard to issues of marriage equality. There are a large number, surprising to me how large it is, number of people who are legal scholars who have written about the use of loving as a precedent. And these people are not simply straight, they're not conservative, they may be part of the community of minority LGBT folks. Their concerns are that sometimes when you analogize from race, you engage in what I call the oppression sweepstakes, trying to figure out which form of oppression is worse than which other form of oppression. They're also concerned that the way in which the problem is talked about suggests that lesbians and gays aren't black too. They're concerned about the fact that the way in which loving is talked about suggests that interracial marriage is not still a problem. I don't know how many of you saw the Cheerio commercial of Gracie and her mom and dad, and mom told her, yes, indeed, you can protect against heart disease with Cheerios, and so she pours a bunch of Cheerios on dad's chest. And that was controversial. You'd think 50 years after loving an interracial couple with a cute kid is controversial. Yes, it's still controversial, suggesting that to talk about loving in a way that suggests that interracial marriage is not so problematic can be thought to be somewhat problematic. And then there's also the problem that the use of loving suggests that some of the material realities that are associated with interracial marriage, that are associated with marriage in general, are being ignored or sort of swept under the table. So there is this body of criticism out there, and I think it's something that we have to think about. It may not relate to the use of loving as a legal precedent. When you're operating within the context of the law, you use precedent as precedent is supposed to be used, and precedent is by and large decontextualized. But when you're talking about struggles outside of the court, when you're talking about politics, when you're talking about conflicts having to do with culture or social equality or economic equality, it's at that point that I think the discussion of loving becomes somewhat more problematic. There's a real question with regard to whether or not loving really had any bearing on black advancement. It clearly was a victory for individual freedom, but what about group advancement? Every time I hear Mildred Loving described as being part Native American, a little bell goes off in my ear, because Indian heritage and white blood were marks of distinction way back when. A white spouse was in some ways more valuable than a black spouse. The question is that true today? When we look at rates of interracial marriage, are we looking at simply a continuation of the old status hierarchy, or are we seeing some real change with regard to the statuses of blacks and other racial minorities as being socially equal? If you look at the data on interracial marriage, the data is equivocal. A recent Pew Center report found that 15% of new marriages were between spouses of different races. 9% of whites, 17% of blacks, 25% of Hispanics, and 27% of Asians married persons of a different race. But with regard to blacks, 24% of all black male newlyweds married outside their race, but only 9% of black females did. And the number of black-white marriages is really pretty low. Of course, the number of black-black marriages is also not comparable to the rate of intragroup marriage for other groups. The Economist reported in January 2013 that as of December 2011, 51% of all American adults were married, 28% had never been. That broke down as 55% of whites, 48% of Hispanics, and 31% of blacks are married. So you've got a lag there with regard to the rates of intramarriage by blacks. I think many of us think that marriage is in trouble. And to a certain extent, the trouble that marriage is in is not part of the debate that we're having with regard to marriage equality. Marriage is becoming more of a bourgeois institution than it once was. If you think about the Lovings, they may have had bourgeois values, but they were not bourgeois. Today, the ability to marry seems to be tied to one's economic standing. A 2012 study by the Brookings Institution found that only women in the top 10% of Americans in earnings saw their marriage rates increase between 1970 and 2012, whereas women in the bottom 65% of earnings had become much less likely to marry, with their marriage rate declining by more than 20%. And this was also mirrored in the experiences of men in the study. Furthermore, marriage seems to be associated with greater financial security. This article from the Times, from which I just quoted, did quotes from a policy research firm that focuses on LGBT populations. It found that poverty rates for gay men and lesbians living alone are more than 20%, compared with 4.3% for partnered gay men and 7.6% for partnered lesbians. And the association between financial security and marriage has implications, particularly for children. So there are some issues that should be part of the general discussion when the subject of marriage equality comes up. That's not to say that loving shouldn't be cited. That's not to say that loving shouldn't be relevant as an iconic expression of what marriage equality involves. That's simply to say that we need to consider how wide the tent is. And we need to consider whether something beyond formal equality is needed to be considered in our active discussion and consideration of the concept of marriage equality. And I agree that this is about loving the opinion, loving the family name of this iconic couple that we associate with the battle for marriage equality, and loving as an emotion that is at the basis of people's desire to marry. And so there are commonalities there. The question is, where should we push the discussion?
Well, now we'd like to allow you to push the discussion. So we'd like to open the floor, and I'd like to invite anyone who has thoughts about the issues that resonate with you. Yes?
Yes, how does the legal community view slippery slope type arguments, questions? I mean, I hear the Supreme Court justices, well, if you want me to accept this, should I also accept this? You see the Supreme Court opinions. I think as a parent, as an educator, sometimes we want to shoot it down right away with our children, but it's used so frequently. How does the legal community view it? Could you speak to that?
Take it back. Slippery slope arguments that seem reasonable, logical, one step away from the problem you're dealing with, or maybe two, are things that judges, in my experience, wrestle with. I can't even count the number of appellate arguments I've done in front of, final courts of the last place you can go. And what most justices at that point aren't persuaded by are 3 or 4 levels away. So, for example, the polygamy argument. If you allow same-sex marriage, then aren't you allowing polygamy? We can sit and debate all day about whether that is a result or not a result, but as a legal matter, that is not going to be determinative in this case. It may, in 1 or 2 justices' minds, be something, but then they already know that they're not going to extend marriage equality to same-sex couples, and so they're packing their argument with these kinds of hypotheticals. But the parade of horribles, the kind of the earth's going to fall apart type things, in my experience, just really aren't. It's not what the argument's all about. Here, it's really all about, in terms of the fundamental right to marriage, and recognizing that. It's all about looking at what fundamental rights have we recognized since the founding of the country. Why have we recognized them? Where have they come from? What other types of fundamental rights might this open up? Not whether it opens up polygamy, just other types of fundamental rights. Because fundamental right analysis, what we call central core fundamental principles that legislation can't change, the legislature can't do anything about. They are core in our Constitution, are limited because we have a government that wants to see democracy and wants to see things hashed out at the local level, the upper level. So that more esoteric legal analysis of why is this a fundamental right when we've done this, which are fundamental rights is going to be really the issue on this principle. Equal protection analysis, that's a different argument, that's a different set of legal principles to wrestle with. But today, that's not loving. Loving is about whether there is a fundamental right to marriage and whether it should extend, and there is, and whether that fundamental right should extend to same-sex couples. So then what does the fundamental right mean? Where does it come from? Is it born out of tradition? Is it born out of constitutional roots? Is there an originalism about it? Where does it come from? And that's much more, if I'm being clear, that's much more what's going to be debated when the court debates it.
You had mentioned that this isn't the first time that interracial marriages have come before the court. You got the impression that several states they got into the state Supreme Court and whatnot. Is this the first time in the federal courts have come?
No.
Tell me about the previous history.
Okay, briefly, because it's so extensive. Since 2004, state Supreme Courts and some federal courts were wrestling with the fundamental right to marry to same-sex couples, same-sex marriage.
I think more than interracial.
Interracial is a different, loving, there had been about 20 years of litigation in state and federal courts concerning anti-miscegenation laws before the Supreme Court took the case up in Loving. there have been about 11 years of active litigation of the same type about same-sex marriage laws before the Supreme Court has now decided to take the major issue up in April. In our case, just, I know you didn't ask, but just for general knowledge, when the Supreme Court decided Windsor a year and a half ago, which said that the federal government, not states, the federal government had to recognize same-sex marriage, but they set up a set of principles that, to me, apply exactly to the states. And since then, there have been something like 23 or 4 opinions of federal courts and state courts applying the Windsor case a year and a half ago to state laws. If it's illegal it's unconstitutional under federal law, it's now unconstitutional under state law. There's been one case that I know of that went the other way. 1.5, basically, cases that went the other way. Well, actually 2. 2.5. But that's it. And let's get Regina
all the
here.
states, where it gets to the state Supreme Court, all the state Supreme Court upheld the ban on interracial marriage.
Well, yeah, New Jersey sort of did, California did not, but then it was turned over at the federal level. New Jersey sort of did, Florida, I think Florida, so it was an intermediate court in Florida that did. Alabama didn't, in a weird opinion. Most of these cases are federal cases. Massachusetts did. Let's see. Vermont did eventually. So most state Supreme Courts that have addressed it went in the way of striking down the statute. But most of the cases are out of the federal courts.
There's a hand in the back.
I think when I came here, my expectations that we were going to talk about the Loving case and miscegenation, interracial marriage, and I didn't know that LGBT rights were going to piggyback off of that program. Because I'm thinking this is March, Women's History Month, which just came off of African American History Month. So I thought we were going to stick to the topic of the Lovings because it's one that has always been on my mind. I've heard of this case, and unfortunately, it's a situation that hasn't been looked at as being an icon in the civil rights movement. And I think because of the fact that we were talking about interracial marriage, and it's everything that we saw that you talked about, the commercial, I saw that commercial, beautiful. And I remember The Birth of the Nation because it's one that you take when you're taking a filmmaking class and all. And every time I see these things, there's always the African American man and white woman. And I remember an African American woman was telling me to never talk about that period and black women and white men. And I think it was here, I heard the case, the history of Darby, and it actually was a white male and a black female. And just things that have been perpetrated upon black women as far as rape also during this period. And no one seems to ever bring that up, during African American History Month or March Women's History, History Month. And some people will probably object to the fact of the LGBT community piggybacking off of the whole struggle and the fight and the violence, for civil rights, which is based on race and not on sex. So if I sat here and argued for the Supreme Court, a case of LGBT, and same-sex marriage, I could probably come up with a lot of cons for it. Because it's not the same, it's apples and oranges. When we talk about same interracial marriage and we talk about same-sex marriage, it's apples and oranges.
I don't want to answer all the questions. I have the answer, but I wanted to
I think you're connecting very well with some of the points Regina made at the outset.
Some of your statements I'm sympathetic to, others of your statements I guess I would say that there's a way to sort of extend them. On the 40th anniversary of the decision, Mildred Loving basically said that, you know, I'm all for marriage equality, and that means that I'm also for marriage equality for same-sex partners. I think she came to understand that although she wasn't a civil rights pioneer as such, that she was making it possible for others who were experiencing similar forms of oppression and degradation to live lives that were enriched by the love of a partner. To a certain extent, the struggle was an individual one to find an ability to express one's humanity in a coupling with an intimate partner. My sense is that she understood that, and my sense is also that loving can be read in that way. And as I said, I'm not talking about the case so much as I am talking about loving as an iconic struggle, the Lovings as an iconic example of the significance of that kind of loving, that kind of intimacy. I do think that you're right that when we talk about women's history, we sometimes leave out folks, and when we talk about Black history, we sometimes leave out folks. And you would think that we could somehow talk about Black and women's history at the same time, so as to create that large tent that I'm talking about, where these sorts of things are not ignored, are raised, are talked about, and where we can sort of go forth with a clear understanding of the complexities of that history. We haven't gotten there under either the women's tent or the minority tent, but that doesn't stop some of us from trying.
Can I say something else? Being a mixed ancestry also, I found the problem here with Loving because, like you said, they say she was part Negro and part Native American. And somehow, when you are Black and Indian, it's like a double whammy. And we really don't even talk about the issues of people who are mixed with, you know, Black American Indian or white American Indian, because what they shared in common was the fact that the American Indians, when they were mixed, have a very hard time, and still do. Civil rights is not, when you have a colonizer and a conqueror, the civil rights is about the people that you conquered. And here in America, it would be about the American Indians being conquered. But when you brought the slaves over and put them in the mix, that created even more of a bigger problem. So the issue is always talked about the civil rights of the African and African descent, but specifically the African and the American, the African and Indian, and the African descendant who has Indian in them, the civil rights haven't even been addressed yet.
Has there been any commentary about this case from the perspective of Native Americans? Either at the time or in retrospect? That's an interesting point.
That I don't know. But clearly there are, in the contemporary discussions, there are the question of non-Black, non-whites is certainly relevant. And at the time of Loving, that was also a concern, because not only did you have the black-white issue, you also had the white Asian American issue. So that this is an area where there has been some history with regard to struggles across racial and ethnic groups. But you're right in saying that the landscape is far more complicated than the discussion in the general population and in the media would suggest. And I think that's the kind of thing that we need to raise, because the umbrella needs to be broadened to include some of what's really happening to people that seems to be irrelevant to our understanding of what civil rights is.
Can I ask, is there anybody else here who is bothered, as the last questioner is, that Loving as a precedent about, is being viewed now today about marriage and the fundamental right of marriage, and somehow feels that therefore it's not being put in its proper context about the completion of continuing problems of interracial marriage, or the other kinds of degregations against women, or particularly black women? I mean, is that shared by anybody else in here? Because and also, the program did say, it's right, the ad program, the write-up for the program is Loving, what does it mean, and how does it relate to the same-sex marriage battle that's coming up in the Supreme Court in a couple of weeks? I mean, that is the focus, and that's why we were addressing it. And I guess we have a lot of work that has to be completed on all kinds of discrimination. But isn't it a source of pride for the people who fought this battle, that they set up a principle that might also, as the professor in Austin said, create a bigger tent for all kinds of people who want the same right? I mean, isn't that something we should be exalting on the 40th anniversary? I mean, Professor Austin referred to Mildred Loving's language herself, but I have it here, and it's not going to take a long time to read it, but this is Mildred Loving's words a few years ago, not my words, her words. She said, "My generation was bitterly divided over something that should have been so clear and right. The majority believed what the judge said, that it was God's plan to keep people apart. Not a day goes by that I don't think of Richard and our love, our right to marry, and how much it meant to me to have that freedom to marry the person precious to me, even if others thought he was the wrong kind of person for me to marry. I believe all Americans, no matter their race, no matter their sex, no matter their sexual orientation, should have that same freedom to marry." And that's Mildred Loving. So I'm not sure I'm assuming most people in this room are not from the right opposing, anything about interracial marriage, same-sex marriage, or anything like that. I assume we're one community. Why would we have any serious discussion among ourselves about the use of precedents like this, whether or not it's in a legal form or a moralistic form or in a public discussion form, about advancing not just the rights of the people who fought for it, but other rights of people who want the same rights? Why is that even much of a discussion? I'm still perplexed, and I've been at this a year, and I've heard this discussion, believe me, a number of times, and it still perplexes me.
We've had somebody to ask a question here, yes.
This is more of a request for personal opinion. I know under the law, a unanimous Supreme Court ruling holds the same weight as a split Supreme Court ruling, but with the potential for a non-unanimous ruling, do you think that the same-sex marriage cases will have the same tipping point effect that Loving did? all those years ago?
No. They're whacked out dudes as far as Hey.
Well, you know, it would be unbelievable it was a unanimous ruling, and given some of the folks on the Supreme Court, I don't expect that. But I really don't think that that's an inside baseball. The headlines will be, let's say when the Supreme Court recognizes fundamental right, or equal protection right, or both right, for folks across this country, same-sex couples to marry. All statutes that are in violation, or the 14 states left, or 15 states left, are all hereby, unconstitutional, period, and full stop, done. What will the tipping point be on that? The civil rights issues of the 60s were the most dramatic things I think we've probably gone through in our country in terms of trying to become a more perfect union. I think they are the touchstones for almost everything else that followed. Women's rights, same-sex rights, all kinds of rights. It is forever will be the seminal things that went on in the United States in terms of our constitutional jurisprudence. I don't think anything is ever going to lessen that or detract from that. But will this result be a tipping point? I think so in many ways, because I think the next shoes that have to start falling are discrimination in hiring. It's the old story in Pennsylvania now. Same-sex couple get married happily, put their marriage picture up on their credenza in their office and get fired for that the next day. There are no protections for that. So all those other things are going to start to fall as the whole discussion changes. And believe me, it's changing. And I think it is changing in a way that is broader than same-sex. It's the tolerance discussion. It's thank God for the new generation. 10 seconds. I was asked to speak at Temple Business School. 250 business school students were sitting there. I've spoken a lot. I can tell when the audience is really with me and they're really passionate about stuff, and they were kind of like, I got to get through this discussion. So I stopped and I said, "You're business school students. Can I ask you, how many people think that this discussion is my generation and it doesn't mean anything to your generation?" 90% of the kids in the room raised their hand, and I said, well then, thank God for the United States, because it's just sweeping across this generation. Now, is it going to be complete tolerance? We saw what happened at the SAE House in Oklahoma. No, of course not. And do they fully understand what they're thinking about when they think about tolerance? Probably not yet. But I think something like this will be, from a relatively conservative court, will be a major statement in the progress towards tolerance and equality generally. That's what.
And remarkably, our time has about elapsed.
Regina would like to say one final thing.
And I also wanted to invite, if there are some teachers in the room that haven't had a chance to ask a question about something related to their work, we'd certainly like to allow that as well. Regina, a final word? Well, no, I guess I guess I'm floored. I think I'm floored. I just don't know. I just don't know what to say to you, Mark.
Can I ask you a question?
Yeah.
Let's say it.
So I work at the African American Museum. We're going to be opening an exhibit this summer that looks at Black and Latino gay ballroom culture. And so one of the things that we're thinking about doing for a public program is doing a screening of the documentary The New Black, which touches exactly on this topic of whether or not same-sex marriage as an issue is becoming the new civil rights movement of the day. And so I'm wondering, as someone who's teaching documentaries in the law, have you seen the documentary?
No, because it's not available. It's definitely not available. I guess I would say that I remember reading something today that indicated to me that that maybe we're being too optimistic about young people. Because they haven't lived through it, and until they come to be confronted by someone who is not willing to take their word for it, and who wants to see something that suggests that they do, that they're willing to give up some of the privileges that they have. We're talking about folks who are privileged. Well, you talked about the Lovings. The Lovings may appear idyllic on the screen, but I suspect that in the time and place in which they were operating, they were not. They were considered to be lower. I mean, they may have been considered trash, to put it bluntly. And it's only in retrospect that they have become respectable. There are still people who are struggling for respectability. There are LGBT people who are struggling for respectability. They are not the poster children for the same-sex marriage cases.
Yes, they are.
I assure you, they are not. They are not the. I mean, I know. You know, the people who were the plaintiffs in the. They were not. They were not. They were not people who were on the corner.
Yes, they were. I'm telling you, they're my clients. They were across the board. Lower socioeconomic, upper socioeconomic.
Yeah, but you can be lower. But the question is your status, and your status within the LGBT community. I mean that is part of what's at issue here. I think income inequality is going to be the next big issue, and it is going to roil our society in a far deeper way than race or sexual orientation or gender has. So I think that it's important for people who consider themselves to be on the left to be open to criticism and not to dismiss that criticism as being the product of some conservative manipulation. I think we have to open our ears and open ourselves to the possibility that there are people who have low status economically, socially, politically, who have yet to find a way to voice their concerns and who are looking to us to move out of the way so that they get the resources that they need to make their case to the larger society.
I agree. I don't think I said anything inconsistent with that, but I agree completely.
Those of you who've been with us through the series, especially the last program at the African American Museum, I think are hearing issues that definitely resonate from one program into the next. So I really want to thank you for being here, and we can certainly continue the conversation informally as we wind down the formal part of this program. So thank you very much.